Hello, everybody, and welcome to the first edition of the Ashburn webinar series for the year 2025. I'm going to be your host today, Stuart Otto, and today what we're going to be talking about is Medicaid Planning 101. Essentially, we're going to navigate what the new numbers are for the 2025 year. As you know, a lot of times, a lot of these federal numbers get updated on an annual basis. So this will be kind of a refresher presentation to talk about how those numbers are going to be impacting your planning, both for the community spouse spend downs as well as the Medicaid applicant. So let's go ahead and dive right into it. As always, if you have any questions, you can submit questions on the panel bar on this webinar presentation. You can also save them at the end as well too. And if you've been doing these webinars before, just note that we may make these webinars a little bit shorter so that we have more time at the end of each presentation to field any questions that you might have that came up during the process. So first thing, let's go ahead and talk about who I am. I am a Medicaid planner with Ashburn. I've been with the company about 1.5 years, but overall I've been in the crisis Medicaid planning industry for over 10 years, and specifically relating to Medicaid compliant annuities. So I work a lot with elder law attorneys all over the country in calculating their spend down plans and getting their annuities set up as well. So been in the industry a long time, and yeah, it's definitely a lot of fun. So let's go ahead and continue here. And so to give you a little bit of introduction on who Ashburn is, if you're not familiar, we are an annuity company that specializes in crisis Medicaid planning and Medicaid compliant annuities. We provide complimentary planning assistance and spend down support for all of our clients. We do have a lot of attorneys that work with us that are more that have been in the industry a long time, so they may not need us for the planning assistance or spend down support. So we're there to supply the annuity as well. We will work with you however you would like to work with us. And then additionally, we do work with A-rated carriers for our Medicaid compliant annuities, which can be very important if you're putting a lot of money into these products. It's nice to have that financial backing as well too. And Ashburn, although Ashburn's been around for about 6 years, we've ourselves collectively, we've been in the industry over 15 years, going on 20. We have a lot of experience here dealing with Medicaid compliant annuities. So if you haven't worked with us before, please give us a try. You'll be very, very glad that you did. And to go over basically our product line, the Medicaid compliant annuity is where we essentially get our bread buttered, basically, for lack of a better phrase. That's what we primarily focus on, Medicaid compliant annuities. But we do also sell tax deferred annuities. One scenario, we would use tax deferred annuities in the state of Texas for spend downs, but they can also be used as a pre-planning tool as well. And then we also have funeral trusts and whole life insurance policies that are guaranteed issue policies, and a nice way to put an additional small spend down, protect small portion of your assets through one of those policies as well too. And then we do also work in the pre-planning side as well with long-term care insurance, and specifically hybrid annuity and life insurance contracts. And so, as I mentioned before, we provide complimentary case analysis, the Medicaid compliant annuity quotes, and the spend down support. A lot of times that spend down support is going to include the spend down of an IRA or a retirement account like a 401k, 403b, funds like that can be put into these Medicaid compliant annuities. Those can be complicated transactions, so we do assist a lot in support there as well too. And then after the annuity is issued and provided to you and the client, we will provide post-policy assistance, primarily regarding death claims. So if your annuitant passes away during the term of the annuity, just reach out to us, and we will coordinate all of the steps with the state, and the client and the insurance company will coordinate all of that so that gets settled in a timely manner. And then we do also provide fair hearing support through one of our partners, attorney Todd Watley out of Arkansas, if there's ever a Medicaid denial because of one of our annuities. We have not had to worry about that to this point, but that's always something that's there if you ever need it. All right, so we're going to talk briefly about our product, the Medicaid compliant annuity, and then we're going to go dive into these numbers here. So the basics of a Medicaid compliant annuity to review is it is a single premium immediate annuity. For those of you in the financial industry, that's a very common term. For those of you that aren't, essentially what that is it's a conversion of a deferred annuity or a lump sum of cash into an income stream. And then one thing that's very important to note that I always tell people about Medicaid compliant annuities is that while all of these annuities are what we call immediate annuities, single premium immediate annuities, they may all be immediate annuities, but not all immediate annuities are Medicaid compliant. So that means there's a ton of immediate annuities out there, a ton of SPIAs out there, but there's not a lot of Medicaid compliant annuities because they're not set up correctly. So you want to be careful if you ever have an annuity come into your office or someone who says, I can sell you an annuity, sell you a Medicaid compliant annuity, when they may not know that it is actually a Medicaid compliant annuity. So just be careful on that. But our Medicaid compliant annuity provides periodic payments to either increase the income of the community spouse or essentially to pay through a Medicaid penalty period. Payments are made by the insurance carrier, and the provisions are in compliance with the Deficit Reduction Act. And these are specifically the requirements, the DRA requirements that I just mentioned. So we've probably been through this a lot over the years, but we'll go over it again as a refresher. But the annuity needs to be irrevocable and non-assignable. So it means zero cash value, means you can't change the ownership on it, and you really should not have any ability to revoke any provision of the contract. That can be a detriment if you have any provision that's revocable. That may be perceived to, show that the contract may be in fact revoked. So we make everything irrevocable in the contract. The annuity needs to be actuarially sound as well, and it would be great if there was a provision in the annuity policy that says, hey, this annuity is actuarially sound. No, we would have to understand how to interpret the annuity as being Medicaid compliant. So there's two things we got to check with regards to this. We want to first check the payout of the annuity. How long does it pay out for? And basically, in order to do, basically why we do that is we want to make sure that it is paid out within the client's Medicaid life expectancy. So every state has a life expectancy chart that they use to determine Medicaid life expectancy. So as long as that term is less than whatever the Medicaid life expectancy is in your state, then that requirement of the actuarially sound test is passed. There is no life or life with period certain options. We do a strict period certain annuity, which means it has a beginning and it has an end. And then also the annuity must provide a positive rate of return. So if you put in $50,000, you should get back at least $50,000.01 at least. But our annuities pay back more than that, obviously. But it has to have a positive rate of return. You can't put in $50,000 and get 49 back. The annuity additionally needs to provide equal payments with no deferral or balloon payments and no inflation riders. And then lastly, the annuity needs to list the state Medicaid program as beneficiary in the appropriate position for the amount of medical assistance paid on behalf of the Medicaid applicant. And in some states, the applicant's spouse as well. And then here's a quick rundown of the parties to a Medicaid compliant annuity contract. We have the owner and the annuitant, who are often the same person when it comes to a Medicaid compliant annuity. The payee, also owner, annuitant, and payee are typically the same person in an MCA contract. So the owner is just the purchaser of the contract. The annuitant is the individual whose death triggers the death benefit of the annuity policy. The payee is the actual individual that's receiving the income payments, and the beneficiaries on there in the event the annuitant does pass away and there's a death benefit remaining, the beneficiaries would be entitled to the remaining proceeds. And then the insurance company is there as well as the obligator to carry out the fiduciary responsibilities of the annuity contract. All right, let's go ahead and dive into the 2025 Medicaid figure updates. And here are the ones that are pertinent to our crisis Medicaid planning situations. So we see every year the Community Spouse Resource Allowance, or the CSRA, is updated. You can see the minimums 31,584, the maximum is 157,920. And then we also have a update in every January for the maximum monthly maintenance needs allowance, which we will get into. I like to refer to it as MIMNA, just easier to say. And the maximum MIMNA number for 2025 is 3,948. And additionally, there are a certain amount of states that do impose what's called an income cap. And those states for 2025 are going to have an income cap of $2,901. We'll talk about that momentarily. And then our home equity limits went up as well too. We really don't get into those very much because that's usually handled on the lawyer end there. But yeah, we've got a minimum of 730,000 and a maximum of just under 1.1 million. And then same since forever, basically, the resource standard for the Medicaid applicant has been unchanged once again. So as you know, the institutionalized individual can generally keep $2,000 in income, in assets, excuse me, sorry about that. But there are a few states, I did list them below, that do have a slightly different number. I believe Missouri and Illinois may be the only ones that actually do the COLA adjustments for that number. Would love to see more states do something like that because this number is severely out of date, but that's still what we kind of plan with in the majority of states. And as far as income goes for the Medicaid applicant, we really kind of break it down into 3 different states. The first state and the most common state probably is that the institutionalized individual's total income must be less than the cost of care. That's the kind of the basic state and kind of simplest state to plan in. But there are also states that do impose the income cap that we talked about earlier, the Miller Trust, or this is where a Miller Trust or a qualified income trust would be required to get past that limit. And then there are several states that do also impose a special income limit. So like Arizona has an income limit equal to what the divisor is, or Colorado has a regional income cap. So those states, we got to plan a little bit differently around. But those are kind of the 3 states that we really 3 types of states that we really deal with. All right, so we're going to go in and talk about the income eligibility for the Medicaid applicant as well as the community spouse. So we're going to talk about income for the Medicaid applicant first. So, and specifically the income cap state. This is the state, again, where if the income is over 2,901, then we would need to establish a Miller Trust to maintain that income eligibility. Now, every state that has this income cap limit has a limit of 2,901, with the exception of Delaware. They have their income cap limit updated to $2,417.50 for 2025. All right, so what is a QIT or Miller Trust? This is a trust that is irrevocable. It's a D4B. It's a D4B special needs trust, and it holds essentially excess income of the Medicaid applicant, income over the allowable limit. So basically anything over the 2,901 income-wise needs to go into the Miller Trust. And so the Miller Trust, some of the key requirements is that it's an income-only trust. You can't put assets in there. It is strictly income. And the funds must be spent from the trust on the applicant's care. And then also because it is in that D4, D4A, D4B, D4C family, there is also a payback provision to this trust, to where if there's any funds left in the trust upon your client's passing, that trust must, the state must be entitled to whatever they paid up to whatever's in the trust. And typically how these trusts work is you put the money in and the money goes out pretty quickly, because that's being used to cover the cost of the nursing home or the client's Medicaid copayment. So here would be a quick example, and this is pretty straightforward, but if we're in a state that has an income cap, say Ohio, that would be an example of one of these states. If you have a Medicaid applicant that has $3,500 of income, we're going to have to put $599, at least $599 into the Miller Trust to reestablish income eligibility, because the $3,500 is $599 over the income cap of $2,901. So in dealing with these trusts, practically how it typically works, the attorney may put the applicant's entire monthly income into the Miller Trust, but that is strictly basically to not have different sources of income that's going to be going to the client's care, basically. And then also we wouldn't be worrying about there being excess income outside the trust as well too. So kind of like a way to avoid the edge of Medicaid eligibility there, putting in more than what is necessary. Just have to make sure that it goes out of the trust. We're not accumulating any income in that trust. And then here are the states that we have on file that are currently income cap states. If you do reside in one of these states, that would be that section would definitely pertain to you. And then here is the income eligibility for a community spouse. Essentially, the community spouse does not have a limit on monthly income. The community spouse, rather, we talked about it earlier, the MIMNA, the monthly maintenance needs allowance, that is an entitlement, essentially a standard that the community spouse is entitled to if they don't have enough. So if the community spouse's income is less than the MIMNA, there is an ability for the institutionalized spouse to move some of that money over to the community spouse to fulfill that standard. That will help reduce the Medicaid applicant's liability to the nursing home and also increase the monthly Medicaid benefit. So this is a great tool to have to help kind of maximize the benefit there for your clients. So the MIMNA, essentially, as I mentioned, is the minimum amount of income the community spouse is entitled to keep when the institutionalized spouse applies for Medicaid. So in order to calculate the MIMNA, we have to first examine what state we're in. And there's really two types of states, or two groupings of states that follow certain MIMNA rules. We have a state where there's only one standard amount, and they apply basically the 3948 across the board. We do have other states, though, that are what I refer to as minimum maximum states, where in that state there's a range for the MIMNA. The community spouse could be entitled to anywhere from $2,555 to $3,948 per month in income. So that minimum MIMNA figure is updated in July. That maximum income MIMNA figure, the 3948, is updated every January. All right, so let's go ahead and kind of put some numbers here into it. We're going to look at an example here with Robert and Nancy. And so let's go ahead and take a look at the maximum MIMNA example first. This is typically the easier one. Here's the states that we have on file here that are simply the one standard states, all of these on this list. The only exception here, all these states would just have the MIMNA as 3,948. However, Alabama is the one state where they've basically imposed one standard, but it's the minimum. So Alabama only imposes the 2005-55 as the limit versus every other state on this list that allows the maximum. All right, so for this case, we're going to assume Robert and Nancy are married. Robert is going to be the institutionalized individual and Nancy will be the community spouse. Robert has income of $3,500. So this would be a situation where we would need to establish a Miller trust if you're in one of those Miller trust states. Nancy has income of $1,435. And as I mentioned, this state allows Nancy to have income of up to $3,948, or I should say at least $3,948. She can certainly have more than that. So in this scenario, the state is going to end up diverting $2,513 of Robert's income to Nancy. That's going to get her up to $3,948 per month in income, and it's going to reduce Robert's copay to $937. And here is the breakdown of the calculations for that. So first we see Nancy's income here, and then we see Nancy's income getting subtracted from the MIMNA standard for Nancy. So we see that she's $2,513 short. So we go ahead and we take that income from Robert. So Robert has $3,500 in income, but we send $2,513 to Nancy. And then also we set aside $50. Each state's different on the personal needs allowance, but we're assuming $50 for Robert in this case, set aside $50 for him to essentially use on his personal needs. And that reduces his co-payment to the nursing home to $937. All right, let's go ahead and take a look at the more complex states, the minimum maximum states. The majority of the states use this minimum maximum range essentially. So if you're on this list, this would be how you would go about doing your MIMNA calculation. So the only thing that's really changing in this scenario is that Nancy's MIMNA is now $2,555 instead of the $3,948. So as you can see, that's going to change the Nancy's entitlement down to $1,120 of Robert's income. So if we look again at the breakdown of the calculations here, you notice that Nancy's MIMNA, the $2,555 minus her income, we get the net shortfall. And then we subtract the personal needs allowance and the shift to Nancy. Robert's copay is now, for this state, $2,330. But there is another option here. So if there's an opportunity for Nancy to have a higher MIMNA than the 2555. So the way she goes about doing that is to calculate what her shelter expenses are. So basically each state has what's called a shelter standard, just like the MIMNA, there's standards for the MIMNA, standards for the resource allowance. There's a shelter standard in every state, and that shelter standard is pretty consistent. I believe it's $766.50 right now. So basically you add up all of this, all of her shelter expenses, and if her shelter expenses exceed $766.50, then we can increase her MIMNA dollar for dollar that she is in excess of shelter expenses. So like if she has $966.50 in shelter expenses and the shelter standard $766.50, then she has $200 extra that she can add to her MIMNA. So her MIMNA would now be $2,755. So as long as that number is positive, you can increase that MIMNA dollar for dollar. But if that number is negative, then the community spouse automatically just receives the minimum, the $2,555. And here are some examples of the different shelter costs. So you see that rent's included in there, or mortgage, and then principal and interest, and then also taxes and insurance for the place of residence. So that can even include renter's insurance, like homeowner's insurance, property taxes. So a lot of that stuff can get very expensive. So it's pretty easy to for a lot of clients to probably have larger shelter expenses, basically. In addition to that, if they live in a condominium and probably an HOA as well too, there's maintenance fees that could potentially be added onto that list as well. And then also each state has their own standard utility allowance, that instead of having to add up all your utilities every single month and give it to the state just says, all right, we're going to allow you a certain amount of dollars for utilities, and you just add that to the shelter expenses. So, and there's a few states that have shelter or utility allowance that exceeds the shelter standard. So there are some states where it's automatically going to be higher than the 2555. But that's the other unit we would add into the shelter cost. So this is the way to get the minimum MIMNA to be, or the MIMNA to be higher than the 2555. And then really quick, the personal needs allowance, that is a state-specific figure that's defined as a monthly benefit for the Medicaid recipient, and they're entitled to deduct that from his or her income that they can pretty much use on their personal expenses. So while most states don't update this manually, there are some states that are starting to update this number. So that is a very state-specific update, basically. All right, so let's go into assets here. So for Medicaid planning purposes, assets are going to be either countable or exempt. And so countable assets are going to be assets that count towards the resource allowance, and then the exempt assets, obviously, are the ones that are not going to be counted towards that. And here are some examples of non-exempt assets, checking accounts, savings, investment accounts, CDs, cash under the mattress, property other than the primary residence, boats, RVs, things like that. And then here are the pretty standard exempt assets. You have the home, the automobile, household goods and personal property, the irrevocable funeral trust, and then in some states they do exempt IRAs as well too. And I'm also going to throw out there that the Medicaid compliant annuity is another exempt asset as well, which is one of the many reasons why it is a really great tool to use for eligibility. So just as a reminder, the individual resource allowance is the allowance that the Medicaid applicant is allowed to keep while on Medicaid. So most states have the $2,000 resource allowance, but there are the other states that may have a different number than the 2,000. So in order to calculate the CSRA, we need to again look at the state from two different views. There are going to be states that implement just a maximum standard, and then there's going to be other states that implement that range. So the states with the maximum is simply going to be the 157,920 across the board. Now, Illinois, South Carolina, I believe, have different numbers for their standard, but pretty much every other state that's in the max only situation is going to have the 157,920. And then the minimum, the states that have the range, it's going to be 31,584. And then here's kind of like a switchboard of which states are the minimum maximum and which ones are simply the max only states. So let's take a look at another example with Robert and Nancy. We'll look at the max CSRA example first. So in this situation, they're going to have $280,000 in non-IRA cash accounts, basically, $280,000 in countable assets. And then they're going to have the home and the car, both of which are exempt in this situation. So in order to calculate the CSRA in a max only state, it is a pretty easy process here. We take the $280,000 and we subtract the resource allowance and we subtract the institutionalized spouse resource allowance. So we get a spend down of $120,080. Now, for practical purposes, like a practical tip here, you want to make sure that this number is, you want to spend down more than the 120. You don't want to just spend down the smallest amount. You want to avoid the edge of eligibility. So like a scenario like this, I would maybe look at 130, maybe 135 or $140,000 to spend down in this scenario, so we're not jeopardizing eligibility by going over. But that's the maximum CSRA example. Here's how we would apply it if this is a minimum maximum state. So assuming the same scenario of $280,000 for their total assets, and we're assuming 280,000 in snapshot assets as well too, because technically we're this number, we should be dividing the snapshot assets here to figure out the CSRA. So in this scenario, we're taking the 280,000 and we're dividing it by 2. That's the calculation that we're going to use in these min-max states. So that calculation gets us a number of $140,000. This number falls within this range here. So this range of 31,000 up to 157,000, 140 falls in that range. Because it falls in that range, the CSRA is going to be $140,000. If this calculation was outside the range, either way, then we'll impose the minimum or the maximum. And then here's the calculation as well that I kind of went over. I apologize for that line being in there at the 142, but basically right over here, total countable assets less the CSRA and less the individual resource allowance, we get a spend down of $138,000. And then again, I would look at maybe $150,000 as the actual amount that we spend down in this scenario. So let's take a look at one more example here in a minimum maximum state. What if Robert and Nancy had $340,000 instead of the 280? So again, their snapshot assets, 340,000 divided by 2 is 170. So in this scenario, the CSRA becomes 157,920 because this number, it exceeds that range. So because it's outside that range, we have to apply the maximum. So, and here's the calculation for that as well. So 340,000 divided by 2. And right here, as I mentioned, because the 170 is greater than the maximum, the CSRA is going to be the 157,920. So down here, we subtract the resource allowance and we get to our spend down of $180,080. And here's a nice little chart that I think a lot of people enjoy having because this will really help attorneys and paralegals and Medicaid planners really kind of quickly assess what an individual's CSRA is going to be. So if the snapshot assets, so we have to look at this horizontally, so follow the color, because if the so looking at the top here, if the snapshot assets of the couple are 315,840 or more, then the community spouse resource allowance is going to be the 157,920. It's going to be the maximum because this number is double this number. So anything greater than this, we're just going to assume the CSRA as this. And then this would be the total protected resource allowance here. Conversely, down here in the blue, if the total snapshot assets are 63,168 or less, then we're going to impose the minimum, the 31,584. And then here's the total protected assets. But if we get into this gray area, and I love that it's a color gray actually, because it is the gray area. If the snapshot assets fall within the minimum and fall within the 63,168 and the 315,840, then the CSRA is going to be half of the snapshot assets of the couple. And then the protected allowance is going to be this number plus the individual resource allowance. So nice table to have. I know a lot of people like to have it for their planning purposes. All right, and one common misconception that we see relating to the snapshot date is that once that snapshot date's established, that you cannot transfer assets between spouses. That's not true. For Medicaid planning purposes, spouses can transfer resources between one another without penalty after the snapshot. The only exception to that, again, they came up before earlier, is Alabama. Alabama has a little bit more stricter, harsher rules when it comes to community spouse spend downs. But for general purposes, for any other state, this should not be an issue transferring assets between spouses. So if you have clients that do have excess resources, here are some of the things you can do to help eliminate those, eliminate that spend down, improve the primary residence or upgrade the primary residence vehicle, buy prepaid burial policies or funeral trusts, pay off debt, and then consider exempt transfers like the Medicaid compliant annuity. All right, so the last thing we're going to talk about here briefly is the divestment penalty divisor. And we're going to kind of talk about it briefly because it is so hard to kind of encompass a universal proposal because each state's divestment penalty divisor is different from one another, because the figures are essentially derived from the average daily or monthly cost for the nursing home in your state. I don't think it's the exact figure, but it is definitely, I would say, within that range. It's supposed to be a reflection of the average state daily or monthly nursing home cost. So we use this figure to calculate penalty periods for improper transfers. Another name for improper transfers is our gifts. So we'll just define penalty period here really quick. It's basically a period of time immediately after the Medicaid application is filed, but before eligibility, in which the client needs the private pay. Because essentially the reason why they're private paying for that period is because they gave away assets that could have otherwise been used to pay for their care. So they did that, and the state's going to penalize them for it. And then the gift is the transfer of assets made within 5 years of the Medicaid application date. And this is another reason why this one's kind of a hard one to do universally. States are going to, many states, not all states, and certainly probably not even half of the states, update this figure in January, but we see this number kind of get updated infrequently, or some states have them randomly updated. They might show up one day where there's a brand new divisor from out of nowhere. So it's a little bit more inconsistent with regards to updates from this figure. And here are just some examples, some of the states that have updated the divisor for January. So I don't believe this encompasses all of them to this point, because some of them are pretty late in getting that number out. I know Wisconsin's still waiting on that one, and Delaware as well too, waiting on those. But here's just a few of the states that have that divisor update right now. All right, so we'll go over a brief calculation of the penalty period, not going into an actual gift annuity analysis, but just showing you how the gift is calculated. So we have a new client, Bob Simpson. He is a single Medicaid applicant in the state of Michigan, a state that updated their divisor. Their anticipated gift on the Medicaid application for Mr. Simpson is going to be $118,420. And with a divisor up to in 2025 of 11,842, we are going to get a 10-month penalty period. If you look down here at the calculation, we are taking the anticipated gift on the Medicaid app and dividing it by the divestment penalty divisor. Now, the interesting thing about this is that had you applied in December, Michigan's penalty period was about divestment penalty divisor was about $1,000 less than this number. So you probably would have had an 11-month penalty period had you applied in December rather than January. So that, so I find that very interesting. And I've seen some states, maybe hold off on that because, they're anticipating a big bump in the divisor or something to that effect, to kind of account for that because it may provide a better economic result for the client. But just know that that's something that, gets considered, around a change of the divisor. So just wanted to throw that out there. And then also looking at the penalty period timeline for Mr. Simpson, this is how it would typically work with us or with our clients. In this case for Mr. Simpson, the penalty would start on February 1st, 2025. And so February would be month 1 of the penalty, March would be the 2nd, April would be the 3rd. What we would also do is have annuity payments commence, assuming we needed to set up an annuity to do this. We would have the first payment of the annuity coincide with the penalty start date of February 1st. So each month an annuity payment is going to be made and another month is going to be served until we get to the 10th month, which is November 1st. That is going to be the last month of the penalty, and that's also going to be the last month of the MCA. So by the time December 1st comes around, the penalty and the MCA is over, they cease to exist, and then Medicaid benefits will begin. All right, so basically a quick wrap up here. We went over all of these different planning figure updates, the CSRA, the MIMNA, the Miller Trust Cap, which are all pretty consistently updated on an annual basis around this time. Again, you'll see the minimum and max, the minimum MIMNA and the shelter standard updated in July. You'll see the standard utility allowance updated in October. And then we went over the divisor and the personal needs allowance, which are more, kind of state specific updates. So, and then the last thing I'll just point out is that we do have state Medicaid guides available on our website. If you go to ashbur.com/state-resources, you can obtain a guide. And I put Tennessee up there because that was a state that probably had a number of different updates for January. So that was a good example for me to kind of show you. And then in addition to the state resources, we also have intake forms for you, case studies, planning tools. You can also submit quote requests online as well too. So anything you need would be right at click of a button for you. So with that, I'm going to turn it back over to Amber with any questions that may have came up.
Thank you, Stuart. That was a great webinar. Thank you. We do have a couple of questions here. I don't know if you want to answer them or otherwise I can take them, but we have one question about do all insurance companies offer like a 10-month annuity in your example of the Michigan penalty period, or are there some restrictions on how short an annuity company will offer the contract for?
That's a great question. The answer to that is no. It's actually very rare to see a 10-month immediate annuity on the market. But that's something that our office does have through American Century. They go as short as 2 months on the immediate annuities to help basically fund the penalty period for the Medicaid applicant. So we would be a great place to obtain that short-term annuity that you need for your client.
Okay, great. And then we have another question here about, do insurance companies that offer Medicaid compliant annuities allow for a disabled child to be named as the primary beneficiary of the annuity, since that's one of the exceptions to the state being listed as primary beneficiary, that they can be in the second position after a disabled child?
Yes, absolutely. I don't foresee that being a problem really with any carrier we work with.
Yeah, I know I've done that with all of the carriers that we are currently working with, just depending on the term of the annuity. They did not require any additional documentation from us to prove that we were listing a disabled child on our end, but it is usually something that Medicaid will ask for as to why they're not in the primary position if you are listing like a spouse or a minor or disabled child before the state as a beneficiary.
Mm-hmm. Yeah, I had thought maybe there may be companies that would request maybe like a guardianship for like a minor if the beneficiary is like under 18. I could be wrong on that, but that might be the only time I would maybe think like there'd be something additional that would be required. But either way, it would definitely be possible to list it. No problem.
Mm-hmm. Okay, I'm not seeing any additional questions that people have submitted. If anybody has any questions after today's webinar, you can definitely reach out to Stuart directly using the email address or his direct line that you're seeing on the screen. I also want to invite everybody to our February webinar. We're going to have Attorney Todd Watley presenting on different exempt transfers that can be made to qualify clients for Medicaid. So be sure to tune in for our February webinar. Stuart, was there anything else you wanted to add before we close out?
No, I just want to say thank you for attending the webinar, and I hope to hear from a lot of you very soon.
Awesome. Thank you, Stuart, and thank you everybody for tuning in to today's session.